No, ma'am. Oh, man, please do not want your phone in the box.
I know, I was just I don't have a purse. I know, I kind of.
Yeah, y'all showing out.
I know, I'm sorry. I know, I'm sorry.
Sabrina, I'm going to put it in my purse.
Okay, thank you.
She's supposed to be in here, but she is out of uniform. She's driving high tie. I said, girl, stay in the back because these people talk about everything. Everything. Keisha, can you see it? Let me see what the bond is on the case, please. F24 19310. Bond. That's it? It's only on one count. All right.
Officer, improve, 02 or 53,
He was asking about you.
I like the way that comment started.
Best for last. Yo. Best for last. Oh, shoot.
You may want to check with the state, but we're ready to go.
Will we be on Zoom?
Good afternoon, everybody. Let's go ahead and get started with the Clenney case. We're here for State of Florida versus Clenney. everybody could announce their presences for the record.
Khalil Clement, Sean Applehoff, Catherine Hogan, Stuart Evans, and Sid Ford.
Good afternoon, Your Honor. Attorney Frank Prieto, along with co-counsel Sabrina Puglisi, Bank MS, on behalf of Ms. Clenney on the F-22-14137.
Mr. Hedrick, you chosen to join us?
Volunteer, perhaps. Yes, I will be probably coming in to work on parts of the case.
Okay. All right.
Judge, as a housekeeping matter, the deposition of Dr. Maricini, which is our medical examiner expert witness, was started yesterday. He was in trial, and Ms. Mess was able to break away from her hearings to take part of that deposition. She had to leave again, so that deposition was not completed yesterday. We communicated with the state, and we do not disagree that they should be entitled to finish that deposition before we move forward on the defense's motion to dissolve Your Honor's pretrial detention order. We think that's appropriate. However you want to schedule that. We offered to finish the depot today, but obviously they couldn't do it. So that just needs to be coordinated hopefully in the next week. But we'll work on that and contact your office ASAP to get that set. So that would leave that portion of the case not for today, obviously subject to your approving that. But I know Mr. Pashadomo still has his motions pending.
Give me 1 moment. Was there anything else that was pending prior to where there were 2 experts that you guys wanted to depose prior to that motion? Did the other one happen? Or?
Yes, Judge, I believe there are certified questions that we will bring before Your Honor. We're going to file that motion, but we do need to finish this deposition before we move forward. So we are asking for the reset.
Okay. Well, you guys go and get a date with Anna once we're done with the other motion, and we'll set up whenever you guys can set up. Okay.
Thank you.
So, Mr. Pascadomo, let me turn then to your motion to intervene and Wash.
Yes, good afternoon, Your Honor. Jude Flachadomo here on behalf of Kim and Deborah Clenney, who were present in the courtroom. We did file, as Your Honor indicated, our motion to intervene under the F-22-14137 case, which is obviously the threshold question before we get to anything more substantive. I'm sure Your Honor's read our motion. I'm happy to expound on it if you'd like.
I have read it. I'll give you a couple minutes to expound on it if you'd like, and then I'd like to hear the state's response.
Sure, Judge. Well, I know Your Honor pulled the rule. It's under Code Rule Civil Procedure 1.230. Obviously, in the absence of a criminal rule procedure governing, we revert to the civil rules of procedure, not unlike, say, in a 3.220H deposition situation where it refers back to the civil rules. If Your Honor looks to the entirety of that motion and the rule to intervene, it's actually very, very broad. I think the exact language is that any party claiming to have an interest may move to intervene. I would proffer to the court that this goes well beyond a claim of an interest. I know at the last hearing, the state's position was that they were objecting to our intervention. Obviously, that was the first time it was raised. I don't know if they're maintaining that position. If the state's position is that our clients do not have an interest in 3 years of their personal iCloud data, I'm sure they can explain that to the court. If their position is that, yes, they do have an interest in it, which I think would be the ethical and genuine position, but that the state's interest trumps that, then I think we can move on to the second motion in our fun filled afternoon here together. But the reality is, Judge, is what we are seeking to intervene on behalf of is that under the homicide case, the state of Florida executed a search warrant. I'll reserve my commentary on that should we get to the second motion. That search warrant allowed the state of Florida to go through the personal iCloud accounts of 2 uncharged, unrelated to the homicide offense, non-defendants, private citizens outside of the state of Florida, starting from November of 2020, which is 2 years prior to the predicate offense to November of 2023, a year and a half after the predicate offense, with no limitations. So what the court has in its file right now are personal, medical, financial, spousal communications, attorney-client communications, all of which the state would very much like to go through. And those pieces of data belong to two parents who are, and I'm assuming the state will concede this point, but were not involved in the homicide offense, which by their own theory is a heat of passion, heat of the moment homicide. It is not premeditated, there's no financial component to it, and yet their seizure through this warrant of the Clenney parents' data is broad and vast, and it is very, very private. And we have an interest in that. And based on that, we are moving to intervene so that we can address the warrant itself, which is the substance of our second motion, because that warrant, in our opinion, never should have even been applied for.
Question to you.
Yes, ma'am.
Do you think that it's a two-pronged test before I allow you to intervene, not only that you have an interest in this, but that the state's interest does not outweigh yours?
So, Your
Or do you
Honors,
think it's just that they have an interest in it, and then you move to the substantive motion itself? Because
that's our position, Judge, but it is Your Honor's discretion under the rule for intervention. You can decide if there is an interest. If Your Honor is going to address that second prong that you just mentioned, I am happy to address that. I don't know if that's Mr. Quinnan's argument. I haven't discussed it with him. If the state is going to proffer that, hey, this is our case and we need to do what we need to do, and our interest in prosecuting this homicide trumps private citizens' privacy rights, so be it. I'll respond accordingly.
But what I'm saying is that you would, I couldn't tell what you were saying, whether or not you thought that that was a two-pronged test for the intervention itself, or that you were saying that the only test for whether or not you're allowed to intervene is whether or not they have an interest.
So
Because
I think we're allowed to intervene, and then Your Honor can address that after we've intervened into it. If you look to the rule itself, it's incredibly brief and direct, and it discusses any party claiming an interest. Now, that interest, I think what Your Honor is referring to is the portion of the rule that discusses whether our interest is subordinate, right? So the court can allow us to intervene, and then when dealing with the substantive issue, make that determination as to whether our interest is subordinate. I think that goes more to the crux of the motion to quash the warrant, because Your Honor is going to be asked to determine if this warrant is so overly broad and invasive that it trumps the state's interest in what it is looking for in this iCloud data so as to continue to prosecute Ms. Clenney.
Your Honor, to crystallize my argument, the rule, the plain language of the rule governs, the rule provides, and I'm going to read it. Anyone claiming an interest in pending litigation may, permissive, at any time be permitted to assert a right by intervention. But the intervention shall, meaning not permissive, be in subordination to and in recognition of the propriety of the main proceeding, unless otherwise ordered by the court in its discretion, which ultimately gives the court discretion. But before we even cross that bridge, there has to be immediate recognition that the rights of the intervener are subservient to the state. I would generally not object to the intervention of a third party who has property interest rights, as to, for example, a firearm, right? A innocent person had their firearm stolen and used in a homicide. Once the homicide litigation is closed, then that person can intervene and take their property, but generally that will be done through agreement. This litigation is ongoing. At the end of the litigation, the defense can intervene and seek to obtain that evidence. But notwithstanding that, that evidence is also not there. We have an expectation of privacy in that information, but that was Apple's records. The Excel spreadsheets with messages were not made by Mr. and Ms. Clenney. They were made by Apple. The list, the business record certification, the inventory of whatever materials they're in, were all made by by Apple. So again, I don't disagree that that expectation of privacy and would have standing, for example, to challenge a motion to suppress where they are charged with defendants, but the material is not theirs. It would be not unlike a cell phone where there's a forensic extraction. They can get the phone, but the data itself is part of the evidence of the case. Maybe there's an appeal, maybe there's a retrial, etc. So, for those reasons, I don't think they should be transferred into.
So you agree that they have at least a privacy interest but not a property interest, and you believe that that privacy interest is subservient to the ongoing case?
Yes, and 3 seconds, absolutely.
So, Judge, and rarely this happens, but I happen to agree that the plain language of the rule does govern here. So the first part of the rule discusses intervening. I think we're getting ahead of ourselves when we're making a determination as to what the subordinate interest is, because that is the subject of the second motion. Once we intervene, we can make our argument to the court as to what the interest of Mr. and Mrs. Clenney is, and the court then weighs that against the state's interest. And that's particularly important, Judge, because I know Your Honor did read our motion, but the warrant application is incredibly vague as to what it is they are looking for in this wide berth of data and how it helps them prosecute a homicide from 2 years prior to when they started looking for this iCloud data. I also think, and with respect to the state, that's a very disingenuous position to take, that Kim and Deborah's private data belongs to Apple. The state of Florida has a robust constitutional privacy interest, and to hide behind the fact that there's a company that acts as a conduit to their data and say that this data belongs to Apple is an end run around their privacy interest. I don't think we're there yet. I'll be happy to go further into those arguments, but it sounds like we are all in agreement that they have an interest. I think we need to move now to the substance of the warrant itself so the court can weigh whether that interest is in fact subordinate or not.
Yes, Judge. The business record certification is not from Kim and Deborah Clenney, it's from Apple Incorporated. So, as it pertains to that aspect, the collateral part, and particularly the intervening part, is in this case quite literally before arraignment. Mr. Prius has brought a motion to essentially close discovery. Anything that would be subject to a public record to not be disclosed as a public record. And then Judge Buscaino denied that motion. The Miami Herald had to intervene in that litigation. In that context, Ms. Clenney's right to privacy was not subordinate to the media and the public's rights. And honestly, the motion was too broad anyway. The point is that they failed to have even pled that the state's interest in evidence in the prosecution of a homicide is somehow less than their right to the privacy, or to the evidence.
So, Your Honor, in response briefly, it is when you have two private citizens not charged with a crime. This is the only avenue of relief that Kim and Deborah Clenney had. So for the state to stand here and suggest that, I didn't understand the argument about the motion prior to arraignment. So I don't know if that was relevant, but to suggest that Apple owns this data, to leave Kim and Deborah Clenney without remedy and the possibility of extreme prejudice to have a government agency go through the most private data for 3 years, I don't know how the state attorney's office stands here and makes that argument. I would suggest we go forward on the substance of it so they can advise the court why this is so important and what they're looking for.
There are so many times that the police do seize cell phones of witnesses or victims or people who are not the defendants in a criminal case, and because they believe that it has evidence, I mean, sign warrants for them often, where they then get the contents of those phones as cell phone dumps, and they're used in criminal cases, and then the phones themselves are given back. I certainly understand the argument but it's not as if this is a novel, something novel that happens. It happens all the time. All the time. This is the first time that anybody's actually been in front of me and made this request where the owner of the cell phone is asking for that information to not be used or to be quashed instead of the state being allowed to proceed with this investigation based on the evidence that was seized during the warrant. I read this rule as saying that this is a two-pronged test before we even get to the substance of the motion, that I make a decision as to whether or not you're allowed to intervene. I don't see that, I mean, I could let you intervene, I guess, as, allows me the may, but given what I know already about this case and about the communication between particularly Mrs. Clenney and her daughter at the time of the homicide, the nature of the relationship before the homicide, the nature of everything that happened after the homicide, and having read through the warrant as to why it is that the state was requesting this information, I'm going to deny the defendant's request.
Your Honor, may I respond briefly?
Absolutely.
Because I understand that Your Honor has ruled on the position of the claims as subordinate. I now need to address that, if nothing else for purposes of the record. So, what we have here is a warrant that asks for iCloud data. Let's be clear about what iCloud data is. And I think we all know, everybody with a cell phone in their pocket has private information on that phone. Let's talk about that private information. We are talking about medical records, confidential. We're talking about financial records, confidential. We're talking about spousal communications, confidential. Photographs, potentially confidential. We know the state read attorney-client messages, confidential. The warrant itself, and I would encourage the court to review it again because it does not speak to anything that could be related to the homicide. And playing devil's advocate, Judge, Your Honor's position regarding the calls between Courtney Clenney and Deborah Clenney. Okay, why is this warrant not narrowly tailored? Why are we looking at private data that dates 2 years prior to, with no restriction in the warrant, Judge? There's no limitation. In fact, I'll read into the record what it is asking for exactly, Your Honor, because it is a little frightening that a government agency in the Miami-Dade State Attorney's Office believes that simply because you are related to somebody charged with a crime, that you are allowed all stored electronic communications or files dating 2 years prior to that crime to a year and a half subsequent to that crime. Let's also keep in mind that the defendant herself was in custody from April of 2022, or from August of 2022, past when that warrant was then issued. She has no access to devices or communications with her parents. Why would they be allowed to see that? Simply because my clients are related to her? That's a very scary, slippery slope, Your Honor. Everybody in this courtroom who maybe knows somebody who was charged with a crime is now subject to the state attorney's search. That's what this warrant says. And that is a slippery slope that we are not inclined to go down. Where is the narrowly tailored warrant as required by statute? And that brings up the issue, Judge, that yes, we understand that this was presented to a judge. We're asking Your Honor to correct what we believe to be an error. Your Honor has the jurisdiction to do so. Previously, my colleague has, during hearings has mentioned his experience as a state attorney and his experience and what he's seen and what he knows. Mr. Clenney. So he's referenced that several times, Judge, and I take him at his word, and he does have significant experience in this courthouse. I've been in here 20 years, and the only thing I know is that I've been wrong before, and I will be wrong again. And anybody in this courtroom who's being honest will say the same. And You as well, Your Honor. The reason I say that, Judge, is because being wrong is not the problem. Not correcting it when you have the opportunity to do so is the problem. If Your Honor is inclined to allow this to stand, I would suggest that it be redrafted and tailored, because what the one area you referenced was the only thing, and I'm taking the position of the state attorney for a moment, is the only thing that could possibly be considered to have any relevance from that wide berth of massive amounts of private information. Florida respects and protects privacy. The state attorney's office drafted a warrant, which frankly, we don't think it should have been signed. I don't think it ever should have been applied for, because it is scary how broad it is and what it is asking for. And so Your Honor's reference to other witnesses and other victims who may have, just because they haven't asked for it back, doesn't mean they weren't entitled to it. So, Judge, I try to avoid doing this, but I am going to ask the court to reconsider its position. I think the sheer breadth of this warrant speaks to the fact that it is a fishing expedition, and it will create an irreparable prejudice to two private citizens who are now not charged for the crime, and open their private information up to be traipsed through by a government agency. That's not something we do. So Your Honor is sitting in the unenviable position of being able to correct that.
All right, Mr. Clenney, I know that, that his argument is being made after the ruling, and we're now getting into a little bit of the substance of the warrant itself, but I would like you to actually respond.
Sure, Judge. As it pertains to the beginning date of the warrant, it begins just like every other warrant on digital evidence in this case, with the beginning of the relationship with the defendant and the victim, at least as far as we can tell, which was November of 2020. The nature of this case, candidly, is the nature of the relationship, because there were only two persons in the one Murray's apartment at the time. One's dead and the other's a defendant. And so a significant portion of the case has clearly been identified through similar fact evidence and nature of the relationship. That, frankly, was a lot of the break in the case as it pertains to Mr. Obumseli's phone records, his prediction of his own murder, the defendant slicing his lip on January 30th of 2022 in Miami, Florida, and telling him to enjoy the hospital, for example. Given that significant digital evidence in that case and surreptitious recordings taken by the victim, there was significant interest in the defendant's communications, including the communications with her mother, which the state contends were indications by her mother for the defendant who would claim self-defense that did not exist. That is our proposition, that is our position. If Ms. Clenney testifies, that Ms. Deborah Clenney testifies, we will cross-examine her in that respect. Because candidly, on the night of the homicide, she did not tell police that Ms. Courtney Clenney was defending herself. So in that respect, we have an interest in Ms. Deborah Clenney's communications with the defendant. We did not get those communications. We could not get into Ms. Courtney Clenney's phone, at least originally. Ms. Deborah Clenney's phone was in Texas, and this honestly presented an opportunity for doing a warrant, might as well do all of them. In finding out, right, an element of a search warrant is evidence that a crime presently exists at the place to be searched. We subpoenaed Apple to find out whether, is there an iCloud backup? And we discovered Ms. Courtney Clenney's accounts was commingled with Mr. Kim Clenney's accounts. The phone numbers are all intertwined. And if necessary, I got to open the subpoena response to essentially outline how each of those accounts were intertwined. And active access was being done to Courtney Clenney's account in December of 2022. I don't know who's accessing it. I don't know how they are accessing it. And frankly, I need to know, especially since Mr. Kim Clenney commingled his account with that person. also requires me to get all of the backups in that intervening period to find out whether anything had been changed or not. So that outlines probable cause, which I think is the second and third last paragraph of the affidavit for the warrant. That actually, let me pull up Mr. Faciadomo's response because it is deceptively quoted in his motion. And I want to make sure I censor it properly. So beginning on page 10 of Mr. Faciadomo's motion, he begins quoting paragraphs of pertinence to Ms. Deborah Clenney's probable cause, and then intentionally omits portions. And I don't necessarily disagree that paragraph 11, 13, and 14 are not necessarily pertinent, but in the end of the conclusion here at page 11, Mr. Faciadomo fails to quote page 11 at the top where it outlines specific probable causes to each of them. It says CTC, there's probable cause to search CTC 496 at need be cause. There's probable cause to search DEB 007, etc. And that's in the affidavit for search warrant. So if the court looks at the top, page 11, and in his motion he did not
Are you referring to the warrant?
the affidavit of the warrant.
Okay, on page 11.
Yeah, ironically.
Beginning accordingly based on brutality of circumstances?
It outlines specific, well, I was discussing both, Judge, but it outlines specific probable cause to each of the accounts. So that is all to say that I honestly have no idea what's on the records. Despite the shots across the bow that we've read all of the messages, we ceased our review immediately upon finding Mr. Creates' message. So I don't know what is in there or not. The only thing I could, and if the court required me to do so under oath, I will say, is the 4 months of messages from April 3rd of 2022 between Ms. Deborah Clenney until January of 2022. And then I did a word search. So I have no idea what else is in there. I don't know to the extent that it is in there. And I should also let the court know that we told Apple, that's plain in black and white in the warrant from November of 2020 to present, Apple provided every single text message Ms. Deborah Clenney sent since 2011. We didn't ask for that. Apple just exports the iCloud returns. So even if we had said from April 1st to April 3rd, Apple is going to provide us everything anyway. So I don't control that. And the bottom line is that it is evidence in this case, the communications that existed between the defendant and her mother who testified, who gave an interview to TMZ claiming that she was told all of these attacks that occurred and the not in those messages are all pertinent substantive evidence in terms of the nature of the relationship and impeachment evidence if they were to testify.
Your Honor, with regard to the paragraph that Mr. Quinn is relying on, it's self-conclusory. You know, it seems to be the state's design to issue how the warrant was drafted, and frankly, we don't find it to. I think it's intentionally misleading. And it's also curious why a pending case in front of Your Honor on a non-exigent warrant was not brought to Your Honor with knowledge of this case, but notwithstanding.
I actually don't think that's typically done. It's typically taken to the on-duty judge, so that the person who's actually overseeing the case is not issuing.
So, Your Honor, the state offers up conclusions as to why the police has probable cause without any detail, based on the totality of the circumstance. Probable cause similarly exists for KDC 50 and KDC 50 at Austin because K. Clenney utilized his own accounts with those of the defendant in an email belonging to the defendant as verification of an email for his own. Okay. What evidence of a crime is there? The state's desire to investigate their case does not trump a private citizen's privacy interest unless they can pinpoint specifically something that establishes probable cause that there will be evidence of a crime or evidence of a future crime. None of that exists in the warrant. This is the definition of a fishing expedition, and it is designed to go directly at the parents of Miss Courtney Clenney. The question for the state is, did they do the same for the victims? Did they do the same for the victims' family members? Because what they are suggesting here, and through this warrant, are telling this court that if you are related to somebody charged with a crime and possibly had communications with them, you are now subject to their invasion, and your privacy interest is no longer paramount to their interest. It is a typical and seemingly theme of this case, that we can do what we want to do, and we're going to do it with or without probable cause. What they say in here, and this paragraph that has no relevance to anything, and makes no reference to anything of worth, cannot be relied upon to say that two private citizens outside the state of Florida as well, Your Honor, should now have all of their personal private information searched. That is a terrifying prospect.
First, my co-counsel here, brought something to my attention too. I meant to also say with regard to financial records, if the court recalls at the Arthur hearing, we contended that the defendant intentionally moved funds to possibly prepare for a flight, which he did flee the jurisdiction, albeit to Hawaii. That was our contention, it still is our contention, and that kind of came out in the cross-examination of Mr. Clenney when issues about commingled funds came up and so on and so forth. That's one. Number two, the distinction between going after Mr. Obumseli's family's records and Ms. Clenney's family's records is that Mr. Obumseli's mom wasn't on the phone with him when he was killed. The defendant's mother was. Mr. Obumseli's mother didn't text him saying it is 20 minutes after not knowing what happened. It is very important, even though you were defending yourself.
I've got a question for you, and I have no idea what the answer to this is, honestly. I agree that there are possibly lots of different things on these phones that could be relevant to your case. So I don't think that it's a pure fishing expedition. However, similar to anybody's phone, there are also lots of records on there that are not relevant to your case. And typically speaking, it is true that a lot of these warrants are not as narrowly tailored as they could be. What power do I have as a judge now to somehow protect some of the more private data that is not relevant to this case, which would be things like medical records or other private communications from the Clenney parents, or quite frankly, in any case, because again, this case is not special in that way. I don't know what power I have after this warrant has been signed, because a lot of it is relevant. I can see why the time period itself is relevant as well, given the nature of the relationship and what's happening after she's arrested. But clearly there are records on anybody's phone that's going to be so extraneous to this. So.
Absolutely, Judge. My son's passport application that's on my iPhone has nothing to do with anything that, for example, might exist or might not exist. And I don't know if that exists or doesn't exist on any of these iPods. I'm only using that because I just did that. The bottom line is that for anything that is beyond the scope of admissibility, then frankly, it is not used. The remedy for anything that is beyond the Fourth Amendment scope is exclusion under that, and I can't use it substantively. Notwithstanding that, I appreciate the court's actually raising that topic because it's part of my outline, albeit I never got to this response, which is they have standing to intervene and move for a protective order preventing disclosure to the public of those materials. Absolutely. But the state has a right to review that because we've outlined probable cause, and which is our threshold, period. There are a ton of things that go towards other records or documents that we both need and is just a natural consequence of doing these searches. For example, even if a forensic examination of my phone, even if only narrowly tailored to the communication between my spouse and I between a week-long period, July 1st and July 7th of 2024, the extraction of that material still produces logs. For example, when my phone was open and closed, whether it was open through biometric measures or through a passcode, whether it was put into charge or not charged. They're just a natural consequence of the forensic extraction. Furthermore, certain aspects of the records, albeit, since I figure there's a stipulation that the records belong to these persons, is the state on occasion has an obligation to prove possession and who controlled it, which honestly, again, is why we had to go through the KDC accounts, because they were commingled not at our direction, but at the direction of whoever controlled those accounts. And I don't know who controlled those accounts. I had to review those records to actually see who was controlling those accounts and what they were doing, and whether evidence of a crime to rape and murder exists on those records, or can download to those records, etc. So, again, as I mentioned, the remedy for them, if they want to preclude the public from finding out personal communications, from finding out financial or medical, is a protective order. And I don't know that I have grounds to object to that. And that would also be a motion to intervene, and I don't know that I have grounds to object to that. As a matter of fact, their privacy interest in that respect would be my interest in the case would be subordinate to their interest. That is the proper aspect of this. But my ability to review those records, ascertain what is and is not evidence in the prosecution of the state of Florida versus Courtney Clenney, is well within my rights as the state of Florida pursuing search warrant.
So, Your Honor, what Mr. Quinn just said there reveals the fundamental issue and misunderstanding of the state of Florida as to the nature of an individual's right to privacy. It's not about the public, it's about anybody. Private is private. And I think one thing we can all agree on, Miami-Dade State Attorney's Office is a government agency. It is a government agency that is looking to go through personal, private records of two people who are not charged with a crime in the hopes that it may find some communication related to its case. Also, Mr. Quinn pointed out, and he's done it twice now, the conversations between Courtney and her mother around the time of the homicide. That actually is something that they may have an entitlement to, but that is nowhere near what they are asking for. They keep referencing that because they're hoping to bootstrap it to say, and that way we can get everything else. Also, the testimony of Mr. Clenney at an Arthur hearing regarding finances, there's no financial component to this offense. The state just said they think it may be related to risk of flight. All of this is state speculation and is unrelated to the prosecution of a homicide, Judge. Let's remember, we're not dealing with Medicare fraud, we're not dealing with mortgage fraud, we're dealing with a homicide. And to then say that private citizens' personal data needs to be reviewed by the state, and to suggest that us reviewing your personal data is not a breach of your privacy is wildly misguided.
Judge, consciousness of guilt is direct evidence of the homicide. If the defendant's moving money to flee the jurisdiction, I'm sorry, Mr. Petrodomo, but that's evidence of the homicide. It gets me an argument if I have evidence of that effect.
But they went fishing for evidence that they had nothing to support that it existed, Judge. That's the crux of this issue, is Mr. Quinn's speculation as to, I may find this, so let me go get this. There's nothing to support that. The testimony of Mr. Clenney as to whether he could post bond or not does not suggest risk of flight, rather the opposite.
So I'm going to stick with my rule, and I appreciate the request to reconsider it. Hopefully you've laid your record. I don't know what appellate remedies there are here, but I think that we covered all of the arguments for this particular motion unless anybody has anything else.
Well, with regard to what Your Honor just raised, so what I'm going to ask is the court to stay the release of the hard drives so we can pursue appellate remedies. My understanding is that the court's ruling in this aspect is a final order as to the movements and would be subject to a direct appeal.
Okay, so let's do this. Let's go ahead. Can you give me a piece of paper so I can go ahead and order a copy of this transcript? And
I don't have a paper, Judge, but I can allow.
Well, there should be actually,
Let me see.
I have my
He have it in there.
or actually chief transcript request right there. And then what I'll do is I'll attach a copy of the transcript to just a written motion that I'm denying this motion and reference the transcript itself.
I was going to agree to this day only because my witness that would take custody of it,
I think it should be-
is not available to take custody of it. Additionally, we were intending to outline, based on the court's ruling regarding the communication between Ms. Deborah Clenney. Yeah, based on the aspects of the privilege ruling, we were essentially going to present to the court the protocol with ASA Deborah and the certain permission. So we were going to ask the court to repeat.
All right, so I will keep these, I will, stay the release of them, I'm ordering a copy of this transcript, it will be back in 10 days, I'm gonna need it sooner than that. I can.
No, Judge, I think as long as there's no prejudice, then 10 days is fine.
All right, so I'm gonna order it, and I will make sure that everybody has a copy of it when I get it.
Thank you.
And I will also attach it to some reference to my order. Okay? All right, thank you all, go and get your next hearing date, if you don't mind putting that out.
That's it. Thank you.
We're off the record, Judge?